So it's 9 o'clock and we'll start. So I would like to welcome everybody for joining this online training from research to market, patenting your quantum technologies. Before we start with the online training itself, I would like to introduce the topic and also give some information on the Quantum Flagship. I guess that most of you were attending the EQTC, which ended yesterday. We had a very interesting presentation from the EPO at the conference. And now we are coming to a more practical part, so the actual online training. I would like to thank those with whom we have organized this. That's the European Patent Office and also the European IP Help Desk, and especially Christian Saltmann, Giovanna Otto, and Riccardo Oltra, and from the European IP Help Desk, Michel Dubini. So, so as I said, a few words about the Quantum Flagship. I guess that most of you are quite aware what the Quantum Flagship is. So it started in 2018, and it was meant as a 10-year initiative with a 1 billion investment. This, I must say, is one of the rare cases where we will surely exceed the proposed investment because next to the European Commission, also the member states are doing some significant investment in the quantum field, as you know. In the ramp-up phase, the European Commission has invested about 150 million and 141 proposals were issued and a little bit more than 20 projects were started. The organization of the Quantum Flagship is to several pillars. So one is on communication, computation, simulation, and sensing and metrology, and the underlying pillar on basic science. The EPO has already started analyzing some of these activities, and we heard that a few days back in the EQTC. So the Quantum Flagship itself is part of, let's say, a broader initiative. And it starts with I would say, Quantera, where member states team up in order to start joint funding activities in the quantum field. Then we do have the Quantum Flagship, and this can be seen as an enabler or technology provider to a broader range of infrastructure activities. So the research and development, and it's said explicitly that the aim of the Quantum Flagship is towards industrial exploitation, so moving up the TRL ladder, and should be seen as a technology enabler and provider to the infrastructure projects, where we have started already a few. And a new thing that it's worthwhile mentioning is the preparation of a dedicated quantum technology fund in order to help startups in this field to grow. So what was our motivation to start together with the EPO and the IP Help Desk, the European IP Help Desk, this online training? So we did a survey in May this year where we asked whether already, what's the experience of the researchers in the quantum field with patenting, and there is only little experience. We had about 100 respondents from different organizations, so company, SMEs, startups, RTOs, and universities. And so this was a motivation for us to team up with the EPO first and discuss whether we should start an online training in this field. So when we asked the survey participants, do you plan to patent in the field of quantum technologies? I think more than half responded it would be likely or very likely. And we asked explicitly whether they would be interested in and attending an online training, and what we have today actually, and the majority said yes. So this was the motivation for us to team up with the EPO and prepare this event. And here you see the agenda of today. So it's a quick welcome, and then I will hand over to Christian, and there will be a case study on the importance of intellectual property in a real case. Then Michelle will give some information on the intellectual property rights for engineers and scientists. Then we have a coffee break, and then Christian again will give some information on how to retrieve patent information. And again, we have a use case and examples. And this will be only the first online training in a series of online trainings. So this is for beginners, and then later on we will, or the EPO together with us, and I guess also the IP help desk will have a more or an online training for more advanced users. Okay, with this I would like to hand over to Christian.
Yes, thank you very much, Markus, for the introduction. I would like to add to the information Markus provided already regarding this training and training that will be offered in the future. For this purpose, I will share my screen with you. What we have planned for you today is a general overview of intellectual property rights and the context in which they are important. It's tailored to the needs of scientists and engineers in the research area, which may commercialize technologies they developed. We will, after this short welcome, start with a case study. The idea here is not to provide information about details of the technical invention, but more about a typical situation in which researchers and engineers are when they develop something in the laboratory or at the workplace. We will then provide some kind of tour d'horizon. Michele and Riccardo will talk about intellectual property rights, registered and informal intellectual property rights, with a focus on patents as the most important means to protect technical inventions. And after the coffee break, as Markus already mentioned, we will talk about patent information, a very important source of information for you as engineers and researchers, to some extent, because they contain technical information, but they can also be very helpful to retrieve business and other information. We will complement this by showing some cases and examples, and we'll do some exercises with you to make it not just theoretical. Markus mentioned already that this is a first event in a series of events for you in the field of intellectual property rights. After this, we will have a second course, presumably in April next year, for advanced topics, which are then even more tailored to your needs in the field of quantum technologies. We'll talk about the commercialization and IP strategies, but also on details regarding the protection of technical inventions in the field of quantum technologies. In the meantime, we will offer offline material for you, so additional documentation, background documents. We have a series of recorded online seminars in specific topics which may be of interest to you. And we also have self-paced courses which you may intend to deepen your knowledge and see what is available in fields that are of particular importance for you. Yeah, that's the intention for you in the field of intellectual property rights. Today, we will aim at a tour d'horizon, so a general overview, and we will start with a use case to shed a bit light on a typical situation of engineers and scientists and how intellectual property, knowledge, know-how, and related aspects play an important role. Should be able to see my presentation. It's a researcher in the field of laser technology. A lady was born in Switzerland, Ursula Keller, who has become a very important researcher in the field of ultra-fast laser technology. And I would like to use this example to illustrate about a bit the problems and the peculiarities of know-how and knowledge in this field. And you can apply these aspects to your own area. So it's common problems, common issues researchers and engineers face when they work in a laboratory or at the workplace and develop something interesting. Maybe a few words regarding her career. She passed her studies in physics at ETH Zurich. She got the Bachelor of Science in 1984. 3 years later, after she had moved to Stanford University, she got her Master of Science in Applied Physics. It already shows a bit the focus of her work. She then did her PhD in Applied Physics at Stanford too, and returned later on after working in the commercial area to Europe, and became in '93 a professor in the ultrafast laser physics laboratory at ETH Zurich. And she made very important contributions to the development and further development of ultrafast lasers. Her scientific achievements are exactly in that area. Before I will shed a light on her major breakthrough, I just would like to get back to the general principle of lasers. We all know that a laser works based on certain components, a gain medium, which is supplied with energy. We have two reflectors, a total reflector, a partial reflector, and it works on the concept of stimulated emission. Mrs. Keller's major contribution to the field of ultra-fast laser physics is the development of the so-called semiconductor sagittal absorber mirror, the so-called SESAM devices, which are extremely useful to create ultra-fast light pulses and which are very well suited to adjust different parameters which are important to tailor the lasers to the needs for specific applications. It's based on a semiconductor structure, a multiple component structure with a quantum well absorber. I just show here an example of a SESAM structure with a substrate and a Bragg mirror, which helps to achieve these properties to create ultra-fast light pulses tailored to specific needs. Scientific track record is very impressive. She has authored and co-authored hundreds of scientific papers. With that, basically, she contributed significantly to the state of the art in the field of ultra-fast lasers and is today one of the most renowned scientists in that field. That is reflected also by a number of rewards she has received. For example, the Charles Hart Towns Medal of the Optical Society in 2015, the IEEE Photonics Award, and the European Inventor Award in 2018. That's maybe not typical, but it's a rather representative career in science and the engineering fields. People develop interesting and exciting things. They publish the results, they are renowned, and they're recognized as experts. There's one little aspect that has to be taken into account when basically the scientific career takes place. It is that when you publish results, scientific results in technical papers, in journals, in books, presented at conferences or show the results in poster sessions, is that you make this information publicly available. That's of course the intention of publishing, but it has some side effects, and we should be aware, especially in the context of the commercialization of technologies. We have to be aware that knowledge, know-how, and related aspects have the characteristic of so-called public goods. It sounds like an abstract concept. I would like to use the opportunity to illustrate a bit what it is. When knowledge, know-how, and related aspects are made available to the outside world, it can be used by everyone essentially without reducing the value for individuals. So that can be phrased in a way that basically if someone else uses this knowledge and know-how that was published, so made part of the state of the art, it can be used by everyone without without subtracting the benefit for the person who created it and anyone else. And that's the so-called non-rivalry aspect of public goods, which are knowledge and know-how. The second one is the so-called non-excludability. When you make information available to the outside world, for example, know-how, how to build semiconductor structures, to build devices and similar aspects which are important for us, it will no longer be possible to, formally speaking, exclude others from using this knowledge and know-how when it's available. Yeah, without legal means, it's literally impossible if you provided all the knowledge and know-how that is necessary to create the structure, to create the device. That's why the protection of this is so important when you would like to commercialize your technologies. Yeah, you have to find a means to prevent third parties from using your knowledge and know-how and benefiting from what you achieved without controlling this use. And one important aspect in that field is that in many technical fields, and I believe also including the many fields in the area of quantum technologies, knowledge and know-how can be reproduced at moderate costs. And the downside of this is, of course, at least for those who created the knowledge and know-how, is that it's so easy to use the knowledge in many cases, while it's so hard and time-consuming and expensive to create the knowledge and know-how. So if you create it and you can hardly benefit because there are others which may use it, who had never made these investments as you did, then basically it's difficult to be successful with your technologies if there is no protection available. Okay, that was the abstract explanation of the concept of public goods and the relationship with knowledge and know-how. What does it mean now in reality, for example, for the lady I'm talking about, Ursula Keller, who was so important in the field of ultra-fast laser technology? Let's take one example. I just take a rather random example in the field of ultra-fast laser physics. You can see here devices that are important to run ultra-fast lasers. And of course, we understand easily that there's a lot of know-how in these devices. For example, the devices as such, the different components that have to work together. And the materials, of course, I mentioned already the sesame example. There are other aspects which are also important, the manufacturing of the devices or of the materials. But there's much more that is important when you use something. Also, the operating of these devices can be very important. What are the parameters that are needed in order to run such kind of device in an efficient and successful way? But that's not all. That's what is usually related to what we have in mind when we talk about inventions, technical inventions. But there's much more around these aspects which are important when you want to be successful on the market. Yeah, for example, the design. It can have a technical aspect, but in most cases, it's largely aesthetic. So the outer appearance of something matters. Or for example, logos and brands, yeah, they help to communicate and send messages to potential users and to customers. They convey something which we would call an image. And that's also very important, and in many areas will determine the decision of future customers, either in favor of products or against it. Then, of course, when you want to communicate with future customers and users, you will use certain channels, internet, for example, and their domain names play an important role. Last but not least, I used here a copy of a brochure for a specific laser. It's information that helps to communicate information, such as text, photographs, drawings in these brochures, but also, of course, on websites as well. And all this is important when you want to be commercially successful. So a good technology, a good technical invention is in many cases a key, but it's not the only aspect that matters. And this morning, we will cover these different aspects in the presentations given by Michele and Riccardo to help you get a general idea of the importance of patent intellectual property rights, what they what they are, what they cover, and why they are so important. Ursula Keller herself, she was not only an excellent researcher and continues to be, but she also co-founded companies that have become very important in the field of short pulsed lasers. For example, she in the 90s co-founded the company Time Bandwidth Products, and a few years later, Gigaterra, which are taken over today and integrated into Lumentum, a US-based company. And personally, I think that was a very clever and very helpful step, not only for her, but also for everyone else who can benefit from ultra-fast lasers, because these technologies really play an important role. And why shouldn't the researcher or engineer do not benefit from the inventions that are made in the laboratory? So there's much more than just being engineers and scientists. Is very rewarding, of course. And I presume that you are interested in this seminar because you have similar aspects in mind in your own field. Yeah, I mentioned the benefits and the economic potential of ultra-fast lasers. They are nearly everywhere today in many fields of technologies. In the automotive sector for micromachining, electronics often use these lasers. They're used for communication. They're quite important today in the field of medical technology, for example, for diagnosis and surgery. And just to give you an idea how big this market is today, although the concept of ultra-fast lasers may be something small and a niche market. The estimates would suggest that a few years ago, the global market was already about 2 billion euros. And it's expected at that moment, it was expected at that moment that the market would increase to about 8 billion until 2023. So within a few years, it would be 4 times as big as it was already in 2017. So it's a huge market. It shows huge dynamics. And I think with that, basically, it's similar to many areas in which you are active. And the good thing is that Europe plays a major role in that, both in research and manufacture of these laser technologies. And of course, there are expectations in Europe, in society, but also in the business, that quantum technologies will show a certain pattern. Of course, this will require that it's not only research, which is excellent, but also the commercialization of the technologies to the benefit of Europe as a whole. Yeah, that brings me to the end of this case study. Again, it was aimed at being a teaser, not providing technical details. I hope I could shed light on the environment in which researchers and engineers are when they create know-how and knowledge and related aspects, and how important it is to have at least an informed view of how this can be protected in order to control the commercializations of the technologies when they have the potential for it. Yeah, that brings me to the end of my presentation. I would like to ask whether there are questions regarding this presentation. Looks like there are any. That's now the perfect moment to hand over to Michele. Michele, you will start to provide a general overview of intellectual property rights, and this will be followed by Ricardo. Michele, may I ask you to take over?
Yes, gladly. Good morning, Christian. Good morning, Marcus, and thank you very, very much for the slot, the invitation. It's a pleasure for me to be here and represent the European IP help desk altogether. I think you should be able now to see my slide. Just please let me know whether you see the presenter mode or the normal mode.
We can still see the PowerPoint program.
Okay, perfect. Then I will make it like this. Is it okay now?
Yeah, perfect. Thank you.
Thanks to you. So it's A pleasure for me to be here. I represent today the European IP Help Desk, which is a service initiative of the European Commission that has been working in the last 21 years, and I've been part of it for the last 8 years as an intellectual property advisor and trainer for the European IP Help Desk. My background is a legal background. I'm a lawyer and I'm specialized in intellectual property and intellectual property rights. What do we do? Just very quickly to introduce the initiative for which I'm working. The European IP Help Desk is basically a frontline service that provides first-line support to anyone who's interested in intellectual property and intellectual property rights, or might have some sort of problems regarding IP law and IP disciplines. We do that by providing trainings, publications online, through our website, and of course through a helpline, which is a question service, so to say. You can ask your direct questions and the experts are going to answer to you in the helpline slot. If you'd like to know more about the European IP Help Desk, please just check out our website, which is on the right-hand side of the screen. And with that, I'm going to end my administrative presentation, and I'm going to start, so to say, with the content related, which is going to be about intellectual property and intellectual property rights. My goal with the presentation is basically to give you a general overview of all intellectual property rights except for patents, which my colleague Ricardo then will analyze in very larger detail. But I'm going to start from the very basic, from the very ground. The slides that I have created are basically provided by previous mistakes that especially researchers have done, for example, in proposal writing, or also in commercialization or exploitation activities. And some of those mistakes are actually very basics, like the one that you can already see in front of your eyes. The vast majority of researchers, for example, that were writing questions to our helpline, were writing to us without a proper knowledge of IP and IPR, for example. And here we are talking about the very basic of the discipline. When we define intellectual property, we are talking about the results of the human intellect, so our creative efforts in a way, and creations that per definition have a intangible nature. Now, the work that is usually carried out by the researchers and the results that you produce throughout your research activities are per definition comprised in the definition of intellectual property. And so you have these intangible assets that can be more or less valuable, and that is the results of the creative effort of your human intellect. Now, beside that, we have the so-called IPR, which are human constructions, juridical constructions that are built for mainly two reasons. The first one is to give an embodiment to this product of the mind that otherwise would be untouchable, would be without a physical form. And secondly, they are used in order to recognize an author, an inventor, anyway, a owner of that intangible invention. Because of course, for something being untouchable, this means that identifying your owner is much harder than, for example, with something you can touch, you can see, you can hold, like a thing or a house, for example. So we always have to remember that IP does not mean IPR, and one, however, is very connected to the other, and without the first, we can never have the second. And as Christian said before, intellectual property is actually all around us. We have seen it in the previous slides, in the previous example with the trademarks, with industrial designs, patents, of course, and therefore we need to be able to distinguish this at least from a very basic levels, like the first distinction that I have provided to you in here. There are intellectual property rights that have to be registered in order to be active and provide you with a right. There are others instead, like copyright, that do not need to be registered in order to be active and provide you with a right, but it is enough, for example, in the case of copyright, to have finished the work of art and to be basically able to start claiming your copyright right. In between, we have the so-called soft IP, which is a gray area that it's something that you may not register actually, because it's valuable only and if you can keep it secret, but not for that is like by definition unregisterable. But we will get through this also in the last part of the presentation today. What we're going to go through between my and Ricardo's presentation today is going to talk very quickly about what designs rights are, trademarks, copyright, trade secret or soft IP, geographical indication, and community plant variety rights. Then I'll leave the word to Ricardo to talk about patents and utility model later on. What I was mentioning before with the relationship between IP and IPR is that IPR is applicable to intellectual property, to certain, however, forms of intellectual property. We cannot use all forms of IPR upon all forms of intellectual property that we have generated. So we need to make sure that we identify the IP that we have generated in order to be able then to identify the IPR that may be applied on that particular piece of information that we have generated. So if we have, for example, just to make you 4 little examples, a technical invention or the development of a new process, then we might apply for a patent protection or a utility model protection, depending on what we have between our hands. In case we have created a new design, a shape, a pattern, a color that does not have a technical effect on the product or on the outcome of the research that we have generated, then we can protect it by design. Or if, for example, we have a very wonderful name for our product, or we have a very wonderful logo through which consumers can actually identify our activities and our entrepreneur status, then we might have the chance to apply for a trademark. Very important is that the decision of applying for one or another intellectual property right does not exclude eventually the chance to apply for another one of them, provided that the IP we have is applicable also to that other IPR. Now, let's talk about the general principles. So we saw there are different intellectual property rights. They might be divided between the so-called registerable and unregisterable, or soft IP as well. But when we are talking about IPR, there are mainly 3 principles that can be applied to all different juridical constructions that the human being has invented in order to protect intellectual property. And they are the following. The first one being the principle of territoriality. Intellectual property rights are territorial rights. That means that they are applicable and valid only in the country or region in which a intellectual property right has been filed and granted. So, for example, if we have filed our trademark at the EU IPO office in Alicante, applying for a European Union trademark, then that trademark is going to be valid for all 27 states of the European Union. But anyone is going to be able to use that logo in the commerce, for example, within the United States, if we haven't filed for protection in that particular country. And that is a very important principle because it's saying to us that we need to be careful about what is our field of play, where we think that we are going to be able to best commercialize our product and therefore concentrate our IPR efforts in that particular territories. And also, if we would like to use something that is already held by somebody else, well, then we can check whether in the territory in which we are, that particular IPR has been registered and granted, and whether, of course, it is active. In case it is not, we're actually free to use the information, although protected somewhere else, but not in that particular territory in which we find ourselves or in which we would like to use the information. Also, secondly, is that intellectual property rights are passive rights. And here as well, we have a common mistakes that is done normally by researchers. Many of them have come to us and said, look, I have filed for a patent. The government has told me that actually my patent is new, my invention is new. But now I've received a cease and desist letter by this particular company that is telling me that I am infringing their patent. But that is impossible because I have a patent, I have a recognition from the government that I can actually step into the market. There is nothing more wrong and more dangerous than that, actually, because a patent, an intellectual property right, is by no means a possibility of stepping into a market, an allowance by the government, the state, to operate inside a certain market, or a certification of lawfulness of the invention of the activities that are going to be carried out. A patent, an intellectual property right, is simply a passive right that allows the owner to exclude a third party from the use of the result that he or she has generated, or commercialize them, or import or export them within a certain territory without his express consent. Stop. That's it. That we have no form of allowance or permission to operate inside a certain market or to commercialize our product only because we have successfully filed a patent and the patent has been granted. Always remember that there are countless cases, unfortunately, that we have received with this question by researchers throughout the last few years. And finally, a common principle of all IPR is their duration. Intellectual property rights are normally existing for a limited amount of time. Depending on the IPR, the amount of time is going to be different. For example, copyright lasts for 7 years after the death of the author. Patents last for a maximum of 20 years after the application has been filed, industrial design for 25 years, and eventually trademarks may be existing indefinitely as long as the owner decides to renew them throughout the time. But also, this is a very clever thing to do. For example, if you're not sure 100% whether the technology that you would like to use is still protected, let's then check when it has been, for example, applied for the first time for the patent. When was it granted? And then, if of course it's longer than 20 years ago, then it's very likely that the technology is for you free to use. Now, a very quick question that perhaps I would like to go through with you, having seen those three points, three principles before. And I have imagined a very small case here that involves a patent that has been granted for the invention A that we can see here on the right-hand side, which is basically a way of closing the shoe. Let's suppose it was not never invented before, and therefore is new and patentable, and it's been patented. And the invention A has been granted as a patent in the territories of France, Italy, and the Netherlands. And then my patent. So I'm going to start to prepare commercializing my product, and I realize, however, that my shoe is actually using the invention B, because I have mounted upon my shoe a very clever sole system that is going to pump off the unwanted air, and at the same time is going to keep out water. That belongs to a third party, although I thought it was actually public domain. Therefore, I mounted that on my shoe. So what do I do now? The first option that I imagine is to go further with the commercialization activities all over Europe. And because I have a patent, and this means that my product is new, so nothing like this existed before I actually invented it, which in a way is true. But if you remember 2 slides ago, as I have explained to you, is very dangerous as well, because it's true, I have a patent, but I have a patent on this invention A here. And so this one here is new, but this one here instead was already existing and is actually belonging to somebody else. So I have a problem to go with option 1. I might have a really serious problem, because I'm going to infringe somebody else's patent. Option 2 says to go further with commercialization activities, but only in France, Italy, and the Netherlands, where my technology is protected. So in this way, I do not infringe third parties' rights. However, you may see that also the second option is based on the false assumption of the first option that we analyzed before. In fact, it doesn't matter that I'm in France, Italy, and Netherlands, so where my patent has been protected and granted, I am still infringing third parties' rights, provided, of course, that this patent here has been also filed in that particular states. So what do? I seek for protection also in other missing EU countries, but still we have the problems of the first assumption. Or the fourth assumption, which is check whether the patent from the third party is still active and request a license, for the technology. What does check whether the patent for the third party is still active mean? It means that I am going to apply the other 2 principles that I've told you before. So first of all, principle of territoriality, which means that I'm going to check where is this patent active in the different European states in which I would like to commercialize my shoes. And secondly, I'm going to see the third principle regarding the duration, and see whether perhaps that patent B that is potentially blocking my commercialization here is still active, or if instead it's older than 20 years, or within these 20 years time somebody hasn't paid the renewal fees and therefore the patent is not active anymore. I would go with option 4. Certainly is the least risky of all of them. Now let's try to go through and analyze quickly individual intellectual property rights excluding patent that we might find throughout our research activities. And actually we filed a couple of them in the office I'm working as a result of research activities besides patents that are, of course, the sacred graal of research, so to say. But beside that, there might be also the chance, for example, to see the value of industrial design somehow, or trademarks as well. But in some cases, plant varieties or geographical indication, well, geographical indication actually very, very rarely, but plant varieties may be a possible outcome. What is a industrial design? Let's go very quickly through the definition. The industrial design right is a right that grants protection to the ornamental or aesthetics feature of a product. It's always very important to remember that here we are protecting only the way a product is looking, not any form of technical features that that particular design might have on the performance, for example, of the product. So improving the performance of the product. That would be again the field of patents. So it wouldn't be the protection of the design. And in order to receive design protection, so register and have a granted design, we need to prove that our design is new and that it has a individual character, so that a person who is expert in the market, in the particular design market of interest, would recognize it and so differentiate it from any other design that were available before. And for example, you can see here the orange juicer on the right hand side. It has a very peculiar design, to be honest, but that design there does not have any form of technical outcome when we are squeezing an orange. However, it is very pleasing, probably for the eye, or very creative in a sense. Therefore, it's protectable through an industrial design. The same applies for the seat of that Vespa. You can see in there, it doesn't really have any form of technical application, but it's pleasant to see, and it is a new form and very original to the eye of a consumer, or also an expert in the field of all the Vespas that you have seen in the past do not have that kind of seat. So it's something new and that looks very original, and therefore is protectable by an industrial design. Now let's go quickly through trademarks. The protection, the duration of the design protection, I told it before, it's 25 years, and they need to be renewed once every 5 years. A trademark. Now, what is a trademark? A trademark is a sign or combination of signs that are used in the trade to identify and distinguish the goods or services from one company to another. The trademark owner is the only one that is allowed to use that trademark in relation to the particular goods or services that he has registered, connected to our logo or name. And he can prevent others from using a substantially identical or deceptively similar trademark in relation to identical goods or services. So you need to know that when we register a trademark, we are also required to choose one or more of the niche classes, which are several different classes that indicate different products or services ensemble. And when we choose, once we choose one of them, we are protecting the use of our particular trademark in the market related to that particular service or good that we have chosen. And unless we are a very well-known trademark, like for example Coca-Cola or Volkswagen, so trademarks that are known by millions of people, we are going to be bound to that particular trademark, to that particular good or service. The duration of a trademark is normally, well, it's 10 years, but we can renew it so 10 years into 10 years indefinitely. Those are a few examples, because you need to know that there are very different kinds of trademarks. We have the simple word, for example. We have the trademark logo, which is the most common known among them. We have also the 3D trademark. You can see, for example, there the Jack Daniel's bottle or the McDonald's fries box as well. There are many different types of trademarks that identify the company that basically have created them simply by their shape, their color, their logo, of course, or their name. When we are going to register a trademark, besides choosing the classes that we are interested into, we also be careful to see that our trademark is distinctive, so therefore it can be distinguished by a consumer. It does not have to be deceptive, of course, and we have the lacto-free example for regular milk here, but also deceptive in the sense that it does not appropriate of characteristics that belong to other entrepreneurs, for example, so that it connects to the use done and the market of somebody else. It does not have to be descriptive, so that with our trademark we can not use a descriptive word for that particular service or goods that we're going to offer, and it does not have to be belonging to the exclusions provided by the law. And on the WIPO website you can see all the exclusion as well as the public order and morality rules that are specified in there. Probably my most favorite intellectual property rights are geographical indications, because they are a form of identification of goods that originate from a very specific region, and therefore they take from that region the quality, the reputation, and other characteristics that actually belong to the region and are transferred to the good only and especially because that good has been produced in there. So they express the geographical origin, but at the same time a form of quality and authenticity of the product, the biodiversity and the traditional knowledge that has been added up in these centuries of a traditional creation of the good, and the development as well of rural areas and social cohesion. But if you'd like to know about more about these last 2 points, I invite you to one of our webinars regarding geographical indications. Finally, we get to the plant variety protections and plant varieties. The plant variety protection, plant variety rights apply to new and distinct and uniform and stable varieties that are generated by the human being. We have a huge part of our trainings dedicated to plant varieties, and we are in a strong collaboration with the CPVO. So if you're interested in this kind of intellectual property rights, do not hesitate to come to our website and write to us, because we have a huge amount of information on plant varieties in there. Now I would end my last minute of this presentation with a quick question again for you, which we will go through again like we did in the previous question. So I have registered my trademark in Europe 5 years ago, and now my business is going well, and therefore it's expanding to the United States, and I would like to register my trademark at the United States Patents and Trademark Office. What should I do then? Well, I cannot do that. 5 years is too long, and the logo is not new anymore. This first assumption is false, luckily. We will see later on in Ricardo's presentation that for patents, novelty and also for industrial design is a incredibly important feature and point. So you're not going to be able to register a patent if it's not new, but that principle is actually not valid for trademarks. So as long as a trademark has not already been registered in the US, you're going to be able to register that independently from the fact that it is not new anymore. The second point, I could register in the US, but only within 1 year from the first application in Europe. Again, this answer takes into consideration some principles of patent law and brings them to the trademark background, which is wrong. You don't have any form of limitation unless somebody else has already registered in the US. In fact, the third answer says I can register in the United States if the trademark is not owned, excuse me for the mistake, by some third party. And fourth, pay attention to that. That is something that seems a little bit odd, but it has happened as a question to the helpline that we have received a few years ago. It says that registering in the US is not necessary as long as I have a EU trademark and that my company is based in the EU. So the convention was that having an European Union trademark and being based in the EU would cover for protection or basically everywhere in the world, which is completely against the principle of territoriality that I was explaining to you before. So the right answer here is number 3. I can actually also register my trademark even 5 years after that I have registered that for the first time in Europe. However, I need to check that nobody else has registered the very same logo for the very same classes in the US before. Now, I think I have drained up the time that I was given, so I would give the word to Ricardo. Are you there, Ricardo?
I am here. Thank you, Michele. Very nice presentation.
May I ask how I can give you the word, or you can do it yourself?
I could take over, but you can simply stop sharing your screen if you want. So that's if you hover above the thing, you will find how to stop sharing.
Yes. Okay, here, got it. Thank you very much.
Very good. Thank you, Michele. Really interesting. Good morning to everyone. For me, it's a pleasure to be here today and to contribute with my grain of salt, which will be about patents, as they told you before. The first thing that I would like to tell you, of course, is that this is just an introduction. I think Christian was mentioning this already. There will be probably more advanced courses later on. So we're going to touch the basic principles and the peculiarities of the patents. So if you already know something about patents, this may be already known or familiar to you, but I hope I can discover also a couple of new and interesting things for each and every one of you. So what is the agenda that I have planned for this next 40-45 minutes? Well, it's simply 3 small parts. First, I will try to explain what is a patent, and how do we distinguish patents from other intellectual property rights, such as the ones that Michele has explained to us just a few moments ago. We will also talk about exceptions and exclusions to patentability, which is a very important topic because not everything is patentable. And last but not least, very important, the patentability criteria. Michele already mentioned novelty. He made already a small disclosure about one of them, but there are more criteria to patentability that are also quite important. If we have time at the end, we may have a round of questions if there are any questions. But before I start, let me have a word about myself so that you know you're a speaker here today. My name is Ricardo Oltra. I'm Spanish national, and I have been working for the EPO for almost 20 years already. I started in June 2002. Before that, I used to work in the industry. I worked for companies like John Deere and Robert Bosch. My background is mechanical engineering, but I am also a physicist. And by the way, while I was studying physics. I did theoretical physics, and I had a lot of quantum mechanics back then. So I'm not entirely unfamiliar with the quantum technologies. At the EPO, I have worked for many years as a patent examiner. And I've been participating basically in all areas of the patent granting procedure, including things like opposition. I've been chairman of opposition divisions for many years. I've been also gerant of classification, and I've been working a lot in training and coaching of new patent examiners and also externally. Nowadays, I am team manager. I lead a team dedicated to agricultural machinery. My specialty, by the way, is smart agriculture. And I am also project manager at TIC. So that's enough about me, because you're not here to just listen about who I am and what I do, but you are probably willing to hear something about patents. So let's start with what is a patent and how do we distinguish patent from the other intellectual property rights that we just saw with Michele. Michele already hinted to the main difference. And he also said that you can have multiple types of intellectual property rights in one same device. We like to use always the example of the iPhone, such as the one you see here in this picture. And this iPhone can have everything that we just mentioned. So it can have, for example, designs like this shape of the iPhone, and you know that it changes from one model to the next. You can register also the trademarks. Michele also told us about this. So trademarks that can be present in such an apparatus like the iPhone could be Apple, iPhone, iCloud, all these kind of things. There are also copyrights for things like the software, ringtones or musics, some images that are used here in the iPhone. There may also be this soft IP, as Michele was referring to it. There may be trade secrets. So the inventors, the innovators, the creators can keep all this secret. But of course, this secrecy can be broken at some time. So at some point, when you have something technical and you want to really protect it, what you do normally is to apply for a patent. Because the main difference of patents as an intellectual property right with the other that we just mentioned is that the patents have a technical character. And we'll go deeper into this concept later on. So we will study exactly what it means that to have a technical character, and how do we assess if this is actually the case when we study a patent application. But for the moment, keep this notion that patents, they need to have a technical character, okay? By the way, there is not just one single patent for one device like this, and something like an iPhone can have maybe between 1,500 and 2,000 patents in it. Just a simple device like this. It's not simple, of course, but it fits in the palm of your hand, and it can have thousands of patents in it. What's the basic contract of patents? Because you saw there were some common points to all intellectual property rights and some differences. So the main difference with the patent is this kind of contract that governments, national jurisdictions do with the owners of the patent. So basically, it goes like this. When you apply for a patent, you agree to make public all the technical details of this invention. You have to make this available to the public. And in exchange, you get the protection. You get this kind of monopoly that, as Michele was explaining, is a passive right that prevents third parties from commercially exploiting this invention. Of course, this is limited to a territory. We saw that with Michele as well. And these territories normally, they coincide with national jurisdictions. And it has also a limited duration, which is a maximum of 20 years. We say maximum, why? Because once you apply for a patent and after a few years, you have to pay renewal fees. But at any given moment, you may decide to stop paying those renewal fees because maybe it is not any more interesting for you to have that protection, or for any other reason. But the main difference, and this is very important, we will see later on as well why this is also important and what consequences it has, is that we made all the details of this invention available to the public. In fact, the very word patent, and I think this will be recognizable by many of you if you have an Italian, Spanish, or Portuguese background or something like that, a Latin language, because in Latin, patere, which is the root of the word patent, means basically to lay open, to make it available for public inspection. So just in a nutshell, this is what patents are. And here you have a picture of a real patent, a European patent, by the way. And maybe to add to what I just said before, and to repeat something which is quite important, although Michele already stressed that also during his presentation, is that patents, they are a passive right. So they do not give you the right to use or to produce one invention, but the right that they give you is that you can prevent third parties from exploiting this invention for commercial purposes. Okay, very good. So what is good about this deal? Why do we have this deal of making the thing, whatever you have invented, public? And on the other hand, the governments, they grant this monopoly. Well, the idea behind this is to try to foster and promote innovation. And in fact, this is the EPO mission. We have it in our mission, and it is at the core of everything that we do at the EPO. And you can read it here. Our mission is to support innovation, competitiveness, and economic growth for the benefit of the citizens of Europe. And how do we do this? How does it work? Well, basically, the main idea is that because all the technical details are public, there are no secrets, there are no trade secrets. But on the other hand, if you're a competitor or if you're someone interested in this area of technology, in getting your company into the market, this market may be restricted by the patents that other companies have. So what you do normally is you build upon that knowledge. You can use the knowledge that the patents give you to build upon them, to innovate, to make something different, something that may be better or work in a different way or maybe cheaper, you don't know, whatever it's interesting for you, and you create a new invention. And then of course you can patent that invention as well. But the idea is that this deal will drive innovation and will make companies become innovative out of necessity, basically, while giving also the benefit to the public that they are all they have at their disposal all this technical information. So this is basically the deal of the patents and why the governments think this is a good deal for everyone, for the public and also for the inventors. But patents are just an intellectual property right, like everything else. So you have a title of a patent, you are the owner of a patent, and you can do many things with it. You can license or even sell it if you don't want it. You can just give your permission without any other sort of compensation. Michele mentioned this already also for during his presentation, that what you need to do is to give explicit consent for others to use it. It doesn't mean that they need to pay you. I mean, of course, you can give consent if they pay you, because that's the deal, or this is what you decide that it's better for you. But you can also make patents available for free. And this has been done in the past with, for example, the vaccination for the malaria. One of them was made available to the public, and Tesla also laid open some of their patents to foster also the market for electrical cars and things like that. So this has been done. But what it is very important is that patents, they are normally used to attract investors and finance further research. And this is also something that happens quite often, especially startups, when they are looking for financing their companies or the things. One of the things that investors looked at is their patent portfolio. So having a good patent portfolio, and this is key for attracting investment to your companies. We have been talking about the territorial extension of IP rights and that they are valid in national jurisdictions. And I wanted to give an idea of the kind of territorial area that we deal with here at the EPO. And it is these 38 countries that you see here marked in red. You will probably notice that they are not the same as the European Union countries. We have more. And this is correct because the EPO, European Patent Office, is not actually a part of the European Union. Is more or less, I wouldn't say the contract, but it is a prerequisite before you enter the European Union to sign the European Patent Convention, because this will it's part of the of getting to a unified market to get the same rules in terms of patent for all these countries. So there are many countries, for instance, Turkey, Switzerland, which are not part of the European Union. They are there. We have also some validation states. We have some extension states as well. So all in all is 44 countries with one procedure for the patents. Of course, for the validation, you still have to validate individually in these countries. This may change if the unified patent comes to fruition, which we hope it will happen soon. And then you can have one single validation, let's say, for the whole European Union countries. But for the time being, this is what we have. But you see, it's a very important area, and it covers, I think, more than 700 million people. But one last thing before we go to the next part, the economical importance of patents. And I said before that it attracts investment, so it is very interesting for the companies, also because it provides this kind of monopoly. So of course, for companies, it is interesting. But I think for everyone and for the whole public, at least here in Europe, it is extremely important. And these studies, they give us already an idea of the big economical importance of IP rights and patents in general. But it is, I mean, I wouldn't even need to see this graphic because, you know, areas like Europe, we have not the industrial capabilities that we used to have years ago. Now we cannot even compete with countries like China, for instance. So the main strength in Europe is innovation. So the innovation is basically the future of European economy. We have to build upon innovation, and it is also shown in many studies that all the companies and that really invest in innovation, they perform better even in situations like crisis, like the one we may have now because of this pandemic. So it is extremely important, innovation, and the best way to monetize innovation is by using patents and IP rights. And these graphs show basically the weight of IP rights and patents in the European economy. As you can see, it's not just that companies with a high activity in IP rights, they represent more or less 45% of the European Union GDP, but also the influence on salaries. So the companies that have high activity in IPR and especially in patents, they normally provide much higher salaries. So just a bit of food for thought about the importance of patents, not just for the companies who are patenting it, but for the whole European public in general. And now, without further ado, I would like to start a bit more the more technical part, if you want, talking about what we call exclusions and exceptions to patentability. We have said before that the main difference of a patent with other intellectual property rights is that patents have a technical character. So these patents are protecting a creation, which is not just an artistic creation, that it could be, you know, protected by a copyright, like literature or music or things like that, but they need to have a technical character, okay? And what do we mean by this? We will see exactly what it means, but the first warning that I have to give you is that the European Patent Convention doesn't give a definition of what it means to have a technical character. However, it gives a list of things that are not considered inventions because they don't have technical character. So when we apply for a patent, one of the first things that examiners do is to test whether this application, the subject matter that is going to be protected, has a technical character or hasn't a technical character. And for this, we use this list of what we call exclusions, because they are not considered inventions. And the list appears in Article 52.2 of the EPC. I will show you in a moment this list, so do not worry. But not only that, there may be things that they are inventions because they have a technical character, meaning they are not in the list that I was referring to, but there may be other reasons why governments have decided that we cannot patent these things, they cannot be protected. And we will see also what kind of things those are. And this is what we call the exceptions. So finally, what can we get a patent for? Well, all the rest. So they need to have a technical character, yes, and they need not to be one of these exceptions. And then we can start examining all the other criteria, like novelty, inventive step, industrial applicability, sufficiency of disclosure, and clarity. We will see this a bit more in detail later. But let's start with the two first things that I said. So things that cannot be patented, exclusions and exceptions. So these things, as I said, exclusions are all those which do not have a technical character, and exceptions, they have a technical character, but they are not patentable for other reasons. By the way, these two things, exclusions and exceptions, are normally interpreted in a very strict sense, meaning that the whole focus of the patent protection need to be in this list, because we have what we call mixed inventions. So you may have a mixture of technical and not technical features in a patent application. This is okay. So as long as the whole focus is not just non-technical, this would be okay. But let's see the list, because I guess you are all very curious about what is these things that we do not consider inventions because they do not have a technical character. So here is the list as recited in Article 52.2 of the EPC, European Patent Convention. So discoveries, scientific theories, and mathematical methods are not patentable because they are not considered an invention. Okay, and again, remember, you may have a claim that mixes a part of a mathematical method with some technical means to carry out this method, and then that's okay. So as long as it is not just the mathematical method, this would be okay. What else? Static creations. Of course, aesthetic creation, if it is just, and this is very interesting, by the way, because you may say colors. This may be just aesthetic choice. You paint your car in red or you paint your car in blue. This is just your own preference. Is this patentable? Normally, no. But what if the color has a technical implication? This can happen as well. You may think, no, I painted my car with a fluorescent color because it is more visible, and this will probably save lives, because the car will be more visible. Okay, this is a technical effect. So as you see, there is always, I wouldn't say a gray line, but it is not very obvious when you have to investigate this list of exclusions and decide whether there is a technical character or not. So what you need to establish very well is whether these features that may or not be or may not be technical, they produce some kind of technical effect. So I make reference again to what I said before, that this criteria is very strict in this sense, that it has to be really non-technical at all, no technical effect derived from these features. And two more things. So schemes, rules, and methods for performing mental acts or playing games or business methods. And also very important, programs for computer. But here we talked about basically the software. The software we saw before is protected with a different intellectual property right. But if what we have is, again, a mixed invention, so we have some kind of computer implemented method to carry out some kind of technical effect, this is patentable according to the EPC. And finally, presentation of information, because this is in most cases also non-technical. It's just a matter of preference. How do you prefer to present? What is your preference to have this information presented, or in the way that this information may be presented to you? So these are the exclusions. But what about the exceptions? To remind you what we said before, these are technical inventions, but they are considered non-patentable for other reasons. And when you see the list, you will immediately recognize why these things are not patentable. So the first thing is inventions that their commercial exploitation would be contrary to order public or morality. This may happen. One good example of this is landmines or the cluster bombs. They are not patentable. Why? Because you know, there are many conventions also worldwide about this type of weapons, but they normally stay, both the cluster bombs and the landmines, they stay in the ground for many years, even when the conflict or the war is over. And there are many civil lives in these areas of conflict that used to be at war, but now are not, that are being affected by these things. So these governments decided that these kind of devices, they are against morality and public order, and of course they are not patentable. Also, plant or animal varieties, also Michele mentioned this, another type of intellectual property right deals with these things, but also essentially biological processes for the production of plants or animals. So essentially biological means basically no direct human intervention. And once more, methods for treatment of the human or animal body by surgery or therapy or things like that, of course, because again, this is something that governments think that that should not be protected. There shouldn't be one company that may prevent other parties to apply these methods. Curiously enough, the methods are not patentable, but some surgical devices used in these methods, they may be patentable. So that's another complication, let's say, to the story. As a summary, everything that has a technical character and is not one of the exceptions may be patentable. And these are things that, well, we saw a few examples, but they are normally divided in what we call entities and activities. So entities would be product, devices, systems. We see here a chair with these two armrests and things like that. But there may be also the activities like processes, methods, and uses, as long as they have some kind of technical character in them, meaning there is a technical effect. We will see a bit more about this when we talk about inventive step later on. And of course, this is not a category, the chemical substances or the pharmaceuticals, but these are products that are also patentable. So we've reached now the critical point of talking about patentability criteria beyond those exclusions and exceptions. So what is needed once you have decided, okay, this is something technical and it is not one of the exceptions? What is needed to be able to obtain a patent on this new invention? Well, the first criteria, and Michele already mentioned before, is novelty. It has to be new. So it has to be something that is not, it doesn't exist before, okay? But then we have two other main criteria, like inventive step and industrial applicability. What do we mean by each of these criteria? Well, novelty is very simple. So it's like if you have ever played this game of finding the differences, and so you get these two pictures, you have to find 7 differences. Okay, so this is more or less what examiners do when they are assessing novelty, but in reverse. What they do is to try to find the similarities, and if everything 100% is disclosed anywhere in the world by means of any public disclosure, then it is not novel. Okay. For doing this, we use the state of the art, and the state of the art is basically, as I said, anything that has been made available to the public at any point. And you can do this by oral disclosure. It can be a patent literature. It can be a web page. It can be an affidavit of someone. So we use lots of means of evidence as long as they are public. So this disclosure is not bound by secrecy or something like that. And not only that, it has to be made available to the public prior to the filing date of the patent application. So if this disclosure has a date which comes after the patent application, of course, the patent application is considered as the first disclosure of this, and this other document wouldn't be prejudicial for novelty. So novelty is basically finding the differences, but in reverse. What happens if there are differences? Well, then we say it is novel, but does it involve an inventive step? And what do we mean by inventive step? Inventive step means that this difference, so whatever we have added as inventors, as innovators to the prior art, that it is something non-obvious. And this concept of obviousness is one of the main challenges that examiners and patent professionals have. Obvious, again, is a word that comes from Latin, obvia, meaning on the way. So it means that if you have to go from A to B, A being your prior art and B being your invention, if this difference is directly on the way to it, then it is obvious. If no, if you have to make some kind of way around it and find different make different steps to get there, then it is non-obvious. We will see a bit more later about inventive step and how we deal with this. But as I said, there is another criteria. I remind you that was industrial applicability. And this has to do with the technical character of the inventions, because patents are granted for inventions in all fields of technology that have an industrial application, including agriculture, by the way. So with this criteria, which, by the way, normally it is fulfilled, but this industrial applicability basically means that we can make this real, that it can work when you apply it to an industry. And here you can imagine, for instance, that things that contravene the laws of nature or the laws of physics, they wouldn't fulfill this criteria of industrial applicability. We always make these jokes with the perpetua mobile. When you have an invention that infringes something like the second law of thermodynamics, then this is probably not industrial applicable. Finally, there are some other criteria. So this is basically what we just discussed, which are sufficiency of disclosure and clarity. So these two criteria of sufficiency of disclosure and clarity, they have a lot to do with that part of the deal that we discussed at the beginning, referring to making public all the details of the invention. So basically, if you want to fulfill your deal, your patent application must contain all the necessary details to carry out that invention, meaning so that a person reading that disclosure can build the same thing, can perform the same method, and be sure that it will work. If you hide information, if there is information missing that would prevent this reader, skilled reader, to carry out the invention, then this application doesn't fulfill the criteria of sufficiency of disclosure. And finally, clarity. This is another important criteria. Why? Because patents, they, as we say, they are a kind of monopoly that concede or grant protection from for the commercial exploitation of third parties to your invention. But of course, when the moment comes that somebody is infringing that patent, or you suspect that someone is infringing that patent, you must be able to prove that there is an infringement. And for that, you need to very clearly establish what is the scope of protection of that patent without any ambiguity. And it happens many times that, because patents, they try to get, of course, the interest of the companies, of the applicants, is to get the broadest scope of protection possible, that the border of this protection is not very well defined in the patent itself. And this is what we call a clarity issue, a clarity problem. It's dealt with Article 84. And it's another thing that we examine very carefully in the patent applications. Well, I hope that the novelty part is clear. As I said, this is straightforward. Let's say at this level, there may be some complications with novelty, but it's simply establishing whether there is a difference or not. But Inventive Step is a bit more tricky. So I would like to use a bit of time to explain Inventive Step and how do we patent examiners assess this criteria of obviousness in a patent application. And for this, we have a tool at the EPO, and it is actually very widely used everywhere else in the world. There are some patent offices that do not use it, but mostly all patent professionals, they use it. They follow this because it is a very structured way to provide arguments in favor or against this criteria of obviousness, Inventive Step. And we call it the problem solution approach. The problem solution approach is, as I say, one of the things that patent examiners struggle with always at the beginning, but it is actually very simple. And I hope that I can give you an idea of how it works that is clear enough for all of you here today. So let's go back again to what we said in a few moments ago. So the first thing that must happen is that this patent application has a technical character and it is not one of the exceptions. And then we assess novelty. And for this, again, we compare with all the prior art, everything that has been made available to the public before the filing date of the application. And if there is a difference, just one difference is enough. And no matter how simple or how obvious or whatever, if there is a difference, then this is novel. So we have the novelty criteria, it's okay, it's fulfilled. But then we need to examine Inventive Step. And for that, we need to focus on this difference. So the first thing we do is to establish the difference, and now we check this difference. First thing that we need to check is whether this difference is technical, because we were saying before that there may be a difference in that the car, for instance, is blue instead of being red. That constitutes a difference in itself. But is this difference of color technical? Well, as I said before, normally no. If it is just a matter of preference because you like this color more than the other, but maybe it has a technical effect. And one example, and I will change the cars if you excuse me, with a tennis ball. One example is the tennis balls, you know, they are painted in these bright yellowish colors. Why? Because they improve the visibility of the tennis ball in the court with the background of the court and the colors that you have in the court. So this color may have a technical effect. Yes. So if it has a technical effect, it is because it is solving some kind of technical problem. So this is why we call it the problem solution approach. So we said, okay, there is a difference, and this difference is a solution to a technical problem. Okay. Well, once we have this, the next step is to determine whether this solution is obvious or not. So going back to what I said before, this solution is directly on the way when we move from A, from the prior art, to B, the invention. Is it there on the way or not? And for this, we use a number of pointers towards the presence of Inventive Step. The first one is, for instance, is this solution known? I mean, in different contexts. Does the skilled person, meaning a person who is skilled in the technical field of technology, reading this patent application, does he know that this is an alternative, that this is something that it can be used instead of what we were using before? Because if this is the case, then of course it would be obvious for that person to apply the same solution. And if it is not known, can it be applied? Can we combine this with the prior art in some way? Well, if we can, okay, that's something, but would you apply it? Because in some cases, the invention is based on what we call breaking a technical prejudice. So, okay, we know that this can be done, but nobody has done it before. Why? Because they all thought it's not interesting, or this is not going to work so well, or whatever. So maybe this new invention is based on finding a way to make this work better. And this, of course, will not be obvious for someone who is a skilled reader of this patent. So in order to delve deeper into this concept, we will need probably 2 or 3 days long course to study Inventive Step. But today I just wanted to give you an idea of what it means for us, this criteria of Inventive Step, which is quite complex in itself. But I hope that this has made more or less clear what is behind. Just to repeat, the main criteria of patentability, novelty. So there must be a difference. Once there is a difference, we need to know whether this is obvious or not. And for this, we use this problem solution approach. So is the difference technical? It provides a technical effect, solving a technical problem. And then is the solution obvious, yes or no? Okay. And once we know this, of course, the industrial applicability that we explained before, and then the sufficiency of disclosure. We need to be able to carry out the invention with the information provided in the patent, and clarity to be able to establish the scope of protection without ambiguity. Well, with that, I reach the end of my my small presentation. I hope it was interesting for everyone. Here you have, of course, our social network contacts, EPO. Maybe it's a good moment, as Christian suggested before, for questions. If there is anyone who would like to share something, opinions, or to ask any questions, maybe that's this is the right moment. I think we have 5 minutes or something like that. Correct, Christian?
Yeah. Many thanks, Ricardo, to you and Michele for the excellent presentations. As we have a few minutes left, we could respond to questions. There are a few questions in the chat, Ricardo. I think they're more related to the technical field, so patents and related rights. The first one relates to the requirement of inventiveness and whether they may be challenged after a patent has been granted.
Very good. That's a very good question indeed. The short answer is yes. During the patent granting procedure, third parties can always, third parties meaning people who are not part of the examining division or the inventor, the applicant for the patent, can always come up with comments. But once the patent has been granted, so the division, the examining division has reached the conclusion that all these criteria are fulfilled and the patent is granted, there is what we call an opposition period, which is open. So everyone in the public has 9 months to say, well, I do not agree with the granting of this patent because, and then they may come up with any of these criteria that we said before, including inventiveness, as you say, to say the patent should not be valid. And then we open an opposition procedure in which the owner of the patent, the patentee, and this party that presented the challenge, they can discuss with a board made out of 3 examiners, normally, an opposition board, to decide whether indeed there is a problem with this criteria. And of course, it can be inventiveness. So the answer is yes, it can be done. Yeah, there is 9 months for everyone to oppose a patent.
Many thanks. The second question relates to the exclusion you mentioned, so exclusion from patentability and mathematical methods. Gerard asked whether what is the situation for machine learning algorithms or artificial intelligence in general? What can be protected?
Mm-hmm. Very good. This is another interesting question. Here, there is not a short answer, unfortunately, because it has to do again with what we call mixed inventions. So the algorithm itself, so the software, these kind of things should not be patentable as such, per se. This will be probably a copyright or something like that, as Michael explained before. However, if this algorithm is used in a technical context using technical means, then yes, it may be patentable. Well, I can give you an example of this. Imagine in my own field of technology, and this is, by the way, something that we deal sometimes with this kind of applications, smart agriculture, as I said. So we have a machine, an autonomous machine, driving through a field, harvesting you know, whatever wheat, corn, whatever is in there. And this machine is autonomously driven, and it has a camera mounted on the front of it that takes video or pictures of what is in front of the machine. And there is a machine learning algorithm there to analyze the images and detect where there is crop and where there is no crop, just to guide the machine to the areas where there is still some crop standing and you need to harvest. Okay, you can have this as a patentable method, as long as you include, of course, that this is guiding a machine and that the effect that it is producing is guiding the machine towards the crop and not. So this would be patentable. However, if you have simply the algorithm, you know, the software that is written for there, this is not patentable.
Thank you so much.
May I steal 1 minute regarding this? Because we have a dedicated webinar, which is going to take place next Tuesday, talking about artificial intelligence. And another one.
Michele, you muted yourself.
My apologies. No, I just wanted to steal 1 second because we have a series of webinar dedicated to artificial intelligence, and the one I put in the chat is the basic. And then on next Tuesday, if Gerard is interested, we're going to have the advanced session. He's very, very welcome to join us in there.
Thank you, Michele, and thank you, Ricardo, for your response. There's another question asked by Marcus regarding the 20 years term of a patent. If I want to build as a company on a technology which has been patented over 20 years ago, are there any legal constraints to be taken into account?
Good question, Marcus. So in principle, no, because as we said, the maximum time is normally 20 years. So in principle, there shouldn't be any protection. Please check, of course, the territorial validity of this, because as Mikel explained, there may be different patents in different jurisdictions with different dates. So make sure that in the territory, indeed, the patent has expired. And another thing that you should take into account is that there may be some extensions. This is not very doesn't happen usually, let's say. But for example, in some pharmaceutical inventions, they are granted extensions because of the difficulty of bringing the product to the market. This means that, for instance, when you have a new drug or a new medicine, in many countries, they have to go through a process, the NSDA, for instance, or whatever agency the country has, they have to approve these drugs before they can be put into the market. And this may take a period of several years. So in these cases, some patents are, they have a longer validity than the 20 years, but this is, as I say, very rare. So if you want a short answer, is no problem. If there is no more than 20 years, there is no protection.
Yeah. Ricardo, if you may allow, I would like to add a detail. There is the situation of so-called dependent inventions. So where is a very special embodiment of the technology qualifies for patent protection because as such, it's considered to be novel, it has an inventive step and also meets the other legal requirements. It may also receive protection. So if the broader invention has expired already, as far as the patent protection is concerned, there may still be patent protection, at least for a special aspect of it. And it's always good to have a look, as Ricardo already said, to look at the national registers regarding patent documents which may be related to patent protection or legal protection.
Correct. Thank you, Christian. Indeed.
Yeah, there is one last question, if you allow, Ricardo, regarding the unitary patent. Karen asked regarding the general situation and, sorry, it's Cathal, regarding protection costs and other aspects. What I may suggest, because there's another question by Carol, to refer to our website for this. The PO has created a dedicated website for the unitary patent system. I saved the link in the chat, so you can use this link in order to get the most up-to-date information in this matter. Also regarding when it will come into effect, we expect it to happen next year, but of course details needs to be clarified. Okay, that brings me to the question by Kirel. If a certain algorithm has been patented for a certain application, can you still patent the same algorithm for another application?
Oh, that's I have to say it depends. It's not easy to answer generally this question, because what we would have to examine is the application in itself. So as I said, the algorithm per se is not patentable if we only have the algorithm. So what we can patent is the algorithm together with a technical application of this algorithm. So I would say yes, it may be possible. So it's not impossible, but it will depend pretty much on what kind of application you have for this algorithm. Yeah.
Mm-hmm. Thank you. Thank you so much. There's another question by Kirel, which may be of interest to all of us. If the EPO has granted a patent, are you covered in all member states, or do you still need to go through follow-up procedure in every member state?
Very good question again. Yes, so indeed, the EPO, it's an international organization, but the national jurisdictions are still national for every country. So what happens is that we have one single procedure where we establish whether this invention is patentable or not patentable. So the one single procedure for all member states. But then once the procedure is over and we have decided, yes, this is patentable, then you have to validate this patent in all the member states that you have an interest in them. So there is basically there is no procedure. It's simply a formal step in which you have to provide, in some cases, translations if this is necessary, because it may be that the country is one of the countries with the languages, the official language of the EPO. So you need to provide some translation and present this application to the national office that they will validate it. So there is just a formal step afterwards in each of the countries.
Mm-hmm. Mm-hmm. Super. Thank you, Ricardo. It looks like there are no further questions at the moment. Of course, we will be happy to receive questions after the coffee break. Many thanks, Ricardo and Michele, for your responses. I hope it was of interest to the participants. We will now have a coffee break until 11 o'clock, and we'll resume with an overview of patent information and how to retrieve this kind of information. So many thanks, and see you in a quarter of an hour again.
Thank you very much.
Thank you.
Thank you.
Yeah, welcome back after the coffee break. I could enjoy the break to recover a bit from the first part of our workshop. I hope you could benefit from our presentations. Michele and Ricardo provided a general overview of intellectual property rights. You learned that there are different kinds of intellectual property rights, those addressing technical inventions. And that was the focus of Ricardo's presentation, but also other kinds of information. We learned that there are registered intellectual property rights, that there are unregistered intellectual property rights, and then there is some kind of gray zone, which is also very important in the everyday life of researchers and engineers, especially when they start to create a company and want to commercialize technologies. In my presentation now after the break, as mentioned already in the morning, I would like to provide a general overview of patent information. And for this purpose, I would like to first talk about the role of patent information in the patent system. With that, you will see that there are large similarities between scientific and technical papers with the purpose to inform the public and the role of patent documents in the patent system. I will explain why patent information is so important. I will then explain how to access patent information, because it's not sufficient to know that this kind of information is important. You would like to use it as you use other sources of technical information, such as Web of Science, Compendics, other sources of data in your everyday life. In order to retrieve patent information in a meaningful way, we have to develop a search strategy. You will learn that there are more than 130 million patent documents just in the EPO's databases. That's a huge amount of data, and without an informed search strategy, you will not be able to retrieve the information you are interested in that. We will explain it because we firmly believe that you have a clear interest in spending your life in the laboratory, at your desk, or at your workplace, rather than selecting important documents in a document amount which has a lot of noise. So by creating an informed search strategy, you will be able really to tailor the search to your needs. And last but not least, in order to make it practical, we will present a use case and a few exercises that should help you to see how in your own area you can create meaningful searches. I mentioned at the beginning, Marco did so too. We will offer a second training later next year, presumably in April, where we'll deal with more details regarding retrieving patent information in your field, so in the field of quantum technologies. Today, we will present a general overview and talk about the fundamentals. Yeah, why is patent information so important? It's good to go a bit back and look at what we discussed prior to the coffee break. The patent system provides a balance of interest. Of course, we have the patent applicants and the patent holders. On the one hand side, we have the public, so society and economy in general. And the patent system try to balance the interest of those who want exclusive rights and those who have an interest in innovation, in information, etc. The patent system, the benefit for the patent applicants and the patent holders of the patent system is that it allows to control the commercialization of inventions, protected inventions. You remember that patents are exclusive rights. Second, with that, it helps patent holders to at least to have a realistic chance to recoup their development costs, so investment in education, in infrastructure, and the time it takes to develop meaningful technologies. The benefit for the public is that the patent system inspires further innovation. It helps to prevent duplication of R&D efforts in industry and in the academic world. And it helps to make the latest technological knowledge available to the public by collecting all the patent information that is collected during the application and granting procedure, collect it, process it, and make it available in high quality. The data and using high quality patent information services, which really help you to retrieve the information you need. Yeah, so the patent information aspect here, because it helps to prevent duplication, it helps to inspire innovation, and it helps to make the latest state-of-the-art available to the outside world, is really a cornerstone of the patent system and not just a side effect. And let's be honest, it's an impressive cornerstone. I mentioned already that today there are more than 130 million documents related to patents and utility models in the EPO's databases alone. That's a huge amount of data, and estimates suggest that about 80% of all technical know-how is only in these documents. And if you just relied on technical literature or scientific literature, using scientific technical papers, textbooks, related databases, you would only see the tip of the iceberg in your technical field. Yeah, and of course, it goes without saying that using this source will help you to get a better understanding of what is available, to avoid to investigate in areas where the results are available already in patent documents, and it will make you stronger because it helps to take informed decisions. Yeah, this huge amount of technical know-how is largely related to the legal requirement that technical information has to be disclosed in detail in the patent applications. It's a legal requirement. Ricardo already mentioned these requirements, and it's a very important requirement, and applicants do their best to comply with this requirement, because otherwise granted patents may be rendered invalid if it turns out that this requirement was not met. There's a pool of documents available. So it includes, for example, published patent applications, granted patents, registered utility models, search reports, and many more. And it's really worth to understand the differences and to use the information at certain stages of your research and during the application and product development process. I'm not sure how many of you have used patent documents already. Maybe it looks like an exotic kind of publication at first sight, but with knowing some details and understanding the structure of patent documents, it's really a piece of cake to use the information whenever you need it. Yeah, each patent document has a title where the invention is described. The inventor is usually indicated, so is the applicant. The document consists of a cover page. This is what you can see here on the right-hand side. It also contains a detailed description of the information, of the invention, how the invention is made, what are its components, what are its main aspects, how is it used, and it at least is shall include information on the advantages compared with what already exists in the state of the art. A very important part of the patent document are the patent claims, because they provide a precise definition of for what legal protection is sought. Many documents also include drawings, especially in the field of engineering, but also in chemistry and many other fields. And it usually contains an abstract, which summarizes the invention. That's, of course, very, very useful if these abstracts are created in a meaningful way to retrieve relevant information. And with that, basically, these documents are quite similar with scientific and technical papers. Let's compare them in a few seconds. On the left-hand side, you see a copy of another patent document. On the right-hand side, you see a typical scientific or research paper. I'm very familiar with these documents, I'm confident. At first sight, they look different, but they really have much in common. So each paper has a source which makes the article unique. To that corresponds the so-called publication number of patent documents. There are three components. First, two characters indicate the patent authority that had published this document. In this very case, it's the German Patent and Trademark Office. Then usually follows a unique identifier. And last but not least, as the third component, the so-called KINE code, which indicates the nature of that document. In this very case, it's the published application, including a search report related to this application. Second, a scientific paper has a title, so has the patent document. I mentioned it already. There's an abstract in both cases. What usually makes a patent document different from a scientific paper is that there is a drawing characterizing the invention on the cover page. Then we have in scientific papers, in many cases, keywords, which are assigned by the authors, at least in many cases. To that corresponds the so-called patent classification codes. And these patent classification codes are assigned by experts in the technical field, mostly by either patent searchers or patent examiners at the competent patent authorities. And we will come to this classification at a later stage. Is very useful information to really identify relevant technical content which you are interested in a very efficient way. That helps to reduce noise, that's quick, and it even covers technical content in documents which are published in languages you may not be familiar with. So very useful, and I will explain at least the basics in a few minutes' time. Yeah. The different reasons why you would like to use patent information. First of all, because you're interested in technical details. For example, because you would like to find out which technical aspects, which technologies already exist, and you may want to build on it, or at least use this information to take informed decision. If something is available already and has been protected, it may be no good idea to reinvest in the same field and duplicate. Second, there is legal information or procedural information related to patent applications and granted IP rights that can be very helpful to check where an invention is protected and where it may not be protected, helping you to take informed business decisions which markets you would like to address. Because with this information, you can avoid the infringement of other parties' IP rights that can be expensive, and they also may be used against you to stop you from taking commercial activities. Just imagine you build a factory to produce a certain device, and it turns out that there is an IP right in that country that is still valid and may be used by the IP right holder to stop you from using the factory. That can be very expensive and spoil your complete commercial strategy. Yeah, so it's very good to use this procedural and legal information to get a clearer view of what happens in certain markets, what is possible, and where there is a risk of infringement. Last but not least, patent information helps to identify business-related information, for example, by checking what others do. Very important to identify, for example, competitors and understand what their strategy may be and in which technical areas they're active. Second, and that's especially interesting for those in the academic world which want to benefit from the commercialization of technologies they develop, but they do either not have the capacity to do so or are not interested in becoming entrepreneurs. In this situation, patent information can be helpful to identify partners, for example, for licensing contracts of the technologies which you have protected. And then last but not least, and it's increasingly important to spot trends in technology or in the market early on by doing some kind of technology scouting that can be done by so-called patent intelligence or patent analytics, which is aligned with what we know as business analytics and business intelligence. So there are different reasons why patent information can be helpful. And they have to address certain questions in the research and business context, which are of particular importance for different kinds of actors, such as IP managers, and engineers and scientists in the research and development area. And questions that can be addressed, or where basically patent information can help to take informed decisions, ranges from questions such as, is our invention new, to, for example, where are the highly competitive markets, for example, to avoid this kind of market if you have not the financial means to enforce IP rights in specific areas and try to identify niche markets, to, for example, what is the value of my patent portfolio, which patents are worth to be maintained, which patents can be sold to someone or may lapse to save money. Yeah, so there's a large variety of questions where patent information can really help to address important questions. For this purpose, of course, we need to be able to access patent information. Patent offices make this kind of information available. They collect the information and they offer interfaces. Also, are interfaces available provided by commercial service providers. They usually offer added value to publicly available patent data to make your patent retrieval procedure, patent searching more efficient, more effective. They may help you to save time and money. Yeah, there's a number of free interfaces you may use today. They're quite powerful. This is just a non-exhaustive list. There are many more. There are some services personally I could recommend, of course, Obviousness. We will come to that during this module. There are usually offered by national offices services for national data, such as offered by the Japanese office, Korean, Chinese office, the US office, WIPO. There are specific data, and if you want to try to address specific questions, like the question which patent information and which patent applications are available in a specific country, then these national interfaces can be extremely helpful. Of course, similar to what we're used to when we use the internet, Google also offers a specialized service for patent information. It's quite powerful. In all cases, it is important to understand what the coverage and what the limits are of these services. That's why it's important, before you do your search and you're interested in comprehensiveness, to look into the coverage of patent information that is available via these services. There are, I mentioned it already, also commercial services available, for example, in the field of chemistry, chemical abstracts, SDN. There's a big provider, Clarivate Analytics, which offers Derwent World Patent Index information. That's data having added value, where titles and abstracts are rewritten by experts in a semi-automated way that help to harmonize terminology and make it easier to retrieve relevant information. They also offer a service, Derwent Innovation. The EPO, just for an example, also has advanced services such as Global Patent Index, which offers more functionality and goes beyond what Obviousness can offer. If you want to do patent analytics, the PATSA product line is a very good candidate to retrieve data and to perform patent analytics. LexisNexis, Mindsoft, Gestel. Today, there's a large number of companies that offer interesting services which have a special character and are very useful to address certain questions. As mentioned already, commercial services offer usually better data, added value data, and it may be useful to use these commercial services and to pay a fee, because in the end, it helps to retrieve more data in a more reliable way and in a more efficient way, because their services, of course, are also advanced services which have more functionality, usually at least, than free of charge interfaces. In our training, I would like to focus on Obviousness, which is today a central source of technical information. It's available free of charge at the website the web address, which I indicate here, worldwide.espasnet.com. It is used by dozens of patent offices worldwide. So it's not only the EPO offering data via Espasnet, but national offices as well for their own data. And it can be very useful to use these national interfaces. Yeah. Espasnet does not only offer European data, it offers data from more than 90 patent authorities worldwide on all continents, industrialized and developing countries, so really provides a wide diversity of different sources. It has a comprehensive collection of patent documents that includes published applications, granted patents, documents which were modified for specific reasons, search reports, and even references to non-patent literature is included, not the articles due to copyright reasons, but at least in many cases there are references available, which can be very helpful for literature survey as well. Yeah, Espasnet offers a user-friendly interface. I will go into that in a second. I mentioned already it's available at worldwide.espasnet.com. I will save the link to Espasnet in the chat and would like you to open this interface because we would like to see more about the functionality, and we also would like to look into some exercises where we want to use Espasnet. So I saved the link in the chat and would like you to open the interface. I will do the same on my screen, so I will stop sharing my presentation and show the interface instead. That's the interface. And the most important aspect of this basic interface is the command line interface, where similar to Google, you can type in keywords, you can type in names, publication numbers, which you have identified somewhere or which were mentioned in an article. There's more than that. I would like to focus on the retrieval of information this morning. We will go into more details during the second training next year. There's also a second interface which is important to retrieve, for example, patent classification information according to the so-called cooperative patent classification. I will explain the basics later on, but the main interface is really what you can see here. If you just retrieve information, I will use one example. Maybe you have identified a patent document, a publication number, which you would like to use in order to retrieve the relevant information. You can type it in either as the number, and we will see that you can also use field identifiers to make your search more specific. I use it right now in a quick and dirty way of patent retrieval. You get the information. If there's only a single document which has this number or discloses this number, it will only show that number. If there are more documents which are related to this kind of string, then a list will be shown. Yeah, this is what is shown. If you type in a patent number, a patent publication number, information is grouped on this screen. You can see here different tabs which disclose different kinds of information. The default tab is for this document the bibliographic data, and it discloses different aspects which are usually displayed on the cover page of that document. What you can see is the applicants which are listed, classification information, priority information, so references to earlier applications for the same applications where the so-called priority is claimed according to the Paris Convention. The application number is mentioned, the publication number, dates, so when something was published or filed is also available. We can see here the title of the document, an abstract. On the right-hand side, you can see already representative drawings you may use in order to get a clearer view of what is covered in the document. A detailed description is also provided as long as the text of the description is available to the EPO. You can see that this document was written in German. That's okay because it's one of the official languages. Eventually, you may not be able to read or understand German, you have the opportunity to use a machine translation to get a better view of it. Of course, it cannot replace an official translation, but at least as a first indication, you may use the machine translation. And I think the quality is quite good these days. For example, if you want to translate it into English, you can do so. I hope you can see my screen now. It's switched to a different tab. What you do see here is the automated translation of the German text into English. If you hover your mouse pointer over it, you can compare it to the original text in order to judge the quality. And I think this can be very helpful to get an idea of documents which are written in a language you may not be familiar with. Okay, then apart from the description, you can see the claims. The same here, basically it's in the language that was used by the applicants during the application and granting procedure. You can also create a machine translation. This is the original text. The ESPOSnet service also offers some kind of automated claim tree where the different claims are related to each other. They're so-called independent claims, which disclose the invention in its broadest way. And then there are so dependent claims, which are embodiments of this invention in its broader way. So they specify something there. The legal scope of this is smaller, and they relate to a broader claim. And in order to get an idea, basically you can use the claim tree. It's not an official tree, but it's based on an automatic analysis of the claim description, and it can be very helpful in this matter. Okay, then there are drawings, very important in many fields. I think it's always good to see a drawing in order to get an idea. I think here for experts, it will be easy to judge the content without reading the text. Of course, both needs to be done, but when you scan dozens of hundreds of documents, the drawings can be very meaningful. Then you have the option to see the original text when it's available. In this very case, it refers to a so-called international patent application. And you have the option to download the data, to download the document in PDF format. Then there are citations, very important. So documents which were either cited by the applicant or the examiner or mentioned in the search report or during some proceedings such as opposition proceedings. Very important to identify other relevant pieces of information in the patent literature. The same applies to the citing documents, so newer documents which refer to the document in question. And basically, it's always recommended to use this feature because work was already invested in order to identify related literature. So similar to what you do when you are new in a technical field and you use review papers in order to get a first idea of the technical field and check the references then to get meaningful specialized papers and read them too. You can use these cited and citing documents to get related documents quickly. Yeah, then legal events, very important. Patent documents are essentially a snapshot of the application and granting procedure and what happens after that. So for example, that a granted patent, a published application, and similar. But of course, there's much more that happens during the application and granting procedure. And in most cases, you would like to understand what is the status? Is the patent still maintained? What happened to the application between the filing and the grant? And this information is so-called legal event information, which is also collected by means of different services. And you're also encouraged to use this information to get a view, because the fact that a patent was granted doesn't mean that the patent is valid. There are different reasons why a patent may no longer be valid. For example, because the maximum term has reached, then it expired, or the maintenance fees were not paid, then it lapses. And all this information can be very useful in order to judge the situation and the options you have for a specific technology. The last tab discloses the so-called patent family. That's a group of patent documents which relate to different, to the same invention, but usually for different countries. It includes the different kinds of documents, such as application, patents, for the same authority, but also the documents for different countries, but for the same invention. If you need more information on that very document, you can go to bibliographic data, and whenever the EPO can, using ESPASnet, establish a link to the national interface for the application, then you will be able to follow using this register link, follow and will reach the national interface. There's also a second service for special offices, for a number of offices, bigger offices worldwide, and other offices which contribute to a specific system, the so-called global dossier, where you can retrieve on the fly procedural information for the different patent family members for these countries. You, in some cases, can even get an automated translation of the text of the events and documents that occur during the application and granting procedure. And it helps you to retrieve extra information. So I think the interface is very powerful, very useful. There's a second aspect I would like to show. I mentioned already the classification search. I will explain the details later, but just to let you know, you can either navigate in the corporate patent classification using this, for example, by clicking on these references for the top sections. There are 8 sections, top sections in the cooperative patent classification, the CPC classification. You can click on it to navigate, see the next level. If you click, for example, here, can see what is below. So it helps you to navigate through the hierarchical structure of the classification. It can also help you to identify the meaning of a patent classification code you identified or saw elsewhere. For example, just type in a specific code. It's related to nanotechnology. You are shown for this code the tree structure and helps you to understand the meaning of this classification code. And contrary to this, you may also look for candidates for patent classification codes that characterize technical content you are interested in. For example, if you're interested in the use of graphene in a transistor, you may simply type in it's not misspelled. Then basically, based on these keywords, a list of results is created, which have either graphene or transistors in the title or abstract. And based on that, statistics is created regarding the ranking of patent classification codes used for these documents. And that can be very helpful to spot relevant areas. Of course, it will still require that you navigate in these systems to spot the relevant classification codes, but it helps you. And that's especially important in view of the fact that the CPC classification scheme has more than 250,000 patent classification codes. So very rich, very detailed, and it's easy to get lost. That's why basically in order to get a first idea, this kind of search interfaces can be most helpful. Okay, that's a general overview of the look and feel of ESPASnet, and we will use ESPASnet at a later stage to do some exercises. I will now stop this and go back to my presentation. So you should be able to see my last slide again, referring to the interface. I mentioned already the classification browser, which is also an asset of ESPASnet and very helpful. As far as the syntax is concerned, you may either type in keywords or names or numbers, as I mentioned it already, using a so-called non-fielded search. But you may also use a fielded search, which is more specific and reduces the noise of your search. So when you know that you're only interested in documents where graphene and transistor is used in the title, just indicate it when you create your search statement. So you can indicate that the graphene should only be used when it's in the title, or a document should only be retrieved when a transistor is mentioned in the title. And you use a Boolean operator to say that I'm only interested in documents where graphene and transistors are mentioned in the title. That helps to make your your specific search more specific, at least in most cases. At the same time, of course, you have to be aware that in some situation you ignore documents which would be identified if you were broader regarding your search statement. The list of identifiers that you may use are indicated in a document, in a guiding document. I will come to that in a second, where you can see how many different fields are available, ranging, for example, from full text, all text or names, or only in the title, or only for applicants or publication numbers, etc. This document also discloses the different formats for dates you may use if you want to search for date ranges, and explains other identifiers and operators too. Yeah, we briefly touched on the machine translation that is available in Espersnet. It's based on Patent Translate. It was developed by the European Patent Office and Google. The intention of this is to reduce the language barrier for languages of the member states of the European Patent Convention, and also reduce the language barrier to other important languages. I mentioned already that there are 3 official languages of the EPO, that's English, French, and German, and Patent Translate allows to translate from these official languages into important national languages of the member states and vice versa, and also allows to translate from other important languages worldwide into English. And these other languages include, for example, Chinese, Japanese, Korean, and Russian. And that's quite a good coverage worldwide of languages. Of course, the EPO continues to investigate whether access to other languages, for example, other Asian languages, may be established. If you need help or get more information about how to use Espersnet, there is important functionality available using the help functionality in the top menu bar. It allows you at least to access a glossary which explains some patent terminology you may not be familiar with. There's a pocket guide, that's the document from which I just have shown a snapshot. It includes information on identifiers, formats, operators you may use. There are tooltips available in Espersnet, and there's also a forum where you can find more information for advanced problems. At the end, I would show that there's even a help desk that you may use. We have online training and much more. Okay, so we have understand that there is data. Data should be available in high quality. The quality of the interface does matter. Now we are prepared to develop and create our own search statements after we understand the importance of search strategies and the importance of developing educated search strategies. There are different concepts available which you may use to create your own search strategy. The most tempting one is, of course, keyword. Simply type it in as we do it for Google. Here's one example which already indicates the problem involved in that. Yeah, if we're interested in documents which relate to LEDs, we may simply use LED as a keyword. But we understand that maybe in some documents, it's not LED, but light emitting diode. So we have to use a second keyword already to increase the coverage. Yeah, also to find documents where LED is not mentioned as an abbreviation, but with light emitting diode as a string. And there are many other ways to describe LED. So, for example, semiconducting materials having a specific bandwidth, yeah, may also be a description for something that could qualify for an LED. And in principle, if you want to aim at comprehensiveness based on keywords, you need to be able to anticipate all the different variations and wordings applicants may have used in their patent applications for this technical aspect. That can be quite demanding. And I can guarantee that in many, many technical fields, some applicants have tried to hide information by using specific terminology or wording you may not expect, so that you may miss documents when you rely on keywords only. A very powerful concept is the usage of patent classes, so patent classification codes. Here are 2 examples. The one for the so-called International Patent Classification. The same code is used in the CPC classification. Then I presented a manual code of the World Patent Index database, a different concept. Sometimes it's complementary, so you may want to use different classifications in order to increase the efficiency and the recall of your search. Then in some cases, you're interested in patent applicants and inventors. For example, if you know already the experts in your technical field and you're interested in whether or not they have filed for patent protection for their inventions or may at least be mentioned as an inventor in these applications. And last but not least, I exemplified that already is the so-called citation analysis to identify cited and citing documents, which really can be extremely helpful in some cases to increase the comprehensiveness of your search. And you're not required to use a single search concept only. You can combine them using, for example, Boolean operators. Here I list the most important ones, for example, to create a set union of elements. So either A or B, or the intersection by using the AND operator, or the not operator to exclude some sub-areas which would otherwise be identified but are not related to what you have in mind. Then Espasnet offers other operators. It also offers truncations. Most search interfaces do. There is no standard for the operators to be used. So in Espasnet, it's an asterisk that indicates a string of characters of any length. That can be helpful if you want to create stemming in your search statement. So just provide the stemming part and then use the operator to extend it to all variations. So with emit and asterisk, you would find emitters, emitting, and many other occurrences of this concept. The question mark in Espasnet means 0 or 1 character. And that can be, for example, very helpful to map American and British English at the same time. This the shark sign, the cross sign means exactly 1 character. And then there are so-called proximity operators, which create a link between 2 search concepts. Let's assume, for example, that you're interested in yellow light LEDs. You may simply use 2 concepts, the first one being yellow light, the second one LED. Based on keywords, you link them using the AND operator, and you will find documents where these 2 concepts occur. But you will create a lot of noise because you do not only identify documents which are about yellow light LEDs, but also those where yellow light is mentioned somewhere because maybe yellow light color on a certain piece and then an LED elsewhere. Yeah, so where there is no semantic relationship between both concepts. And the proximity operator helps you to increase the likelihood that these 2 concepts are related in a semantic way. They belong together. And that can be very helpful to reduce the noise in your research result. Okay, I mentioned already that there are patent classification schemes. They're generally assigned by independent experts, mostly patent examiners and patent searchers at patent offices, but they can also be independent experts at the commercial service providers who understand the technical field and have no interest in hiding the information. By contrast, their intention is to make the information available in the most useful way for you. So to lower the barrier for you to find the information. Second, patent classification schemes are typically hierarchical in nature. They have a tree-like structures. There are exceptions to these, but this can be used as a general rule. They're constantly revised and updated to keep pace with the changes in a technical field and to map upcoming new technical fields as well. There are different classification schemes available. I just would like to mention the most important ones in the patent world. The central one is clearly the International Patent Classification Scheme. It's used by more than 100 patent offices worldwide. It's administered by the World Intellectual Property Organization in Geneva and is updated once a year. The Cooperative Patent Classification Scheme was jointly developed by the European Patent Office and the US Patent Office. and is today used by more than 30 patent offices worldwide. While we have for the IPC classification scheme, 10,000s of classification codes available. In the CPC classification code, in the CPC classification scheme, there is more than 250,000 patent classification codes. So the level of detail is usually much higher than in the CPC classification code. The benefit of the IPC classification code scheme is that it's used by more offices. Yeah, so with the IPC classification scheme, you can identify technical content in many documents worldwide where you don't speak the language. The clear benefit of the CPC classification scheme that it allows you a much more specific search. And just as a side remark, important is to know that the CPC classification scheme builds on the IPC classification scheme. The CPC classification scheme is updated more frequently than the IPC classification scheme. That means 4 times a year, as opposed to once a year for the IPC classification scheme. So 2 very important classification schemes, and we've seen already how to retrieve CPC codes in ESPASnet. Yeah, if you want to investigate further and have an interest in IPC classification codes, there are 2 interfaces I can recommend. The first one being the official one in English and French, administered by the World Intellectual Property Organization. A second one in English, French, but also German, using a search interface offered by the German Patent and Trademark Office, where information can be displayed in a synoptic way, which can also be helpful in order to identify translations in different languages for technical subject matter. Yeah, we have seen already the classification search interface for the CPC classification scheme, and I also believe that this can be very helpful for you at your workplace. Yeah, let's have a look at an example. This is a use case I chose in order to illustrate a bit how you can search for specific technologies. I used the example of magnetorheological dampers for knee prosthesis. The underlying problem is, of course, you need certain elastic properties of these dampers. Otherwise, it can be very painful for those who have these prostheses in order to use them in their everyday life. And one effect that can be used is the so-called magnetorheological dampers, so the elastic and viscous properties of materials can change as a function of the magnetic field that is applied. Here we do see Hugh Hare. He's an entrepreneur who developed this kind of dampers for knee prosthesis and other aspects of these prostheses to make life better for those who have to use them. I think it all started when he was himself affected by some kind of accident, by this problem to use them. And I would like to start the example by presenting a short video. Most likely I have to change the presentation first. So it may take a few seconds before I can do so.
This is the world's first reusable cotton swab. It removes up to 5 times.
Okay, you will be able to see the video in a second. And you should also hear the sound.
My singular goal was to become the greatest mountain climber in the world. At the age of 17, I set up to climb Mount Washington. What we intended to be a single day out ice climbing turned into a 4-day winter epic. Both my biological legs were amputated due to tissue damage from frostbite. I was fitted with prostheses, and I was shocked by the lack of technological sophistication. I said to myself, this cannot be what exists in this day and age of space travel. At that time, I made it my mission to advance prosthesis. In fact, it was only 12 months from when my limbs were amputated that I was climbing at a more advanced level with artificial limbs than I'd ever achieved before the accident. My research group here at MIT has a long history of innovation, where we developed an artificial knee to be used by people that are amputated above the knee, that has a brain, it's able to sense its environment, so it auto-adapts. As a person moves, it figures out how to modulate its own resistance to enhance the biomechanics of its wearer. We've developed a bionic foot ankle device. This is the first prosthesis in history that's powered, that emulates lost muscle function. With this, it actually injects energy into the walking or running gait. Within minutes, often, a person can walk normally and says to us, I have my body back, I have my life back. Here at MIT, we're advancing the fundamental interfaces between the human body and the built design world. Electrical interfaces, mechanical, dynamic. We're developing the fundamental building blocks for the elimination of human disability. So I just love to signing up. I love every few months upgrading my own legs so I have better balance, I can move faster. It's interesting because my biological body, as I age, gets worse and worse due to age-related degeneration, but the artificial part of my body gets better in time. So I predict when I'm 80 years old, my balance will be better than an 18-year-old.
Okay, personally, I think it's a quite impressive example. It also indicates a bit what is necessary today to develop technologies and products, because we did not only see the dampers or the prosthesis, but devices, processes, computers play, of course, an important role. And all that relates to technologies and needs to have a closer look at, to take an informed decision regarding protection, either a yes or no, but it needs to be informed. Now we are back at the presentation. You should see the slide again. And this was just a teaser in order to help you better get the context. When we want to look for these dampers, the magnetorheological dampers, so those which have special properties as a function of the external magnetic field, we will not rely on a single search strategy only, usually when we aim at a high recall, so at comprehensiveness. Schematically describing it, we will use searches which are based on CPC codes, on IPC codes, for example, on CPC codes and combined with keywords, and if necessary on keywords only, in order to increase comprehensiveness. Usually there's an overlap between these searches, so we'll find documents again and again, but there may be documents which cannot be identified by a search strategy based on CPC codes, because the information is published by a patent authority that doesn't use CPC classification, and we don't get it from other sources either. Yeah, so there can be really reasons to use different concepts in order to increase comprehensiveness. And it depends on the situation where you need it. If it's just a quick and dirty search and you have a good CPC classification code, and you can expect that the technology is important in a country where the patent authority uses CPC codes, then it's a very good recommendation to start with CPC codes. But there may be other situations where you use other concepts. Yeah, when you would like to carry out this multiple search strategy where you use different partial searches with the intention to increase efficiency, you may follow what I would call the onion skin approach. You start with the core area and then add further layers of search steps which may complement it to the level necessary. The core level, I mentioned already, can be in many cases CPC codes. For example, for this very case, there is something in the medical field for knee joints, and there's a specific classification area for magnetorheological fluid dampers. If you combine them using the AND operator, you may get documents which can be very specifically addressing this technical field. And if you just want to know whether there are documents, then the answer is already yes, and you can stop the search. Of course, if you want to get a better view a more detailed view or more comprehensive view, because you have to take an informed decision regarding whether or not to enter into a prototyping phase. Then you have to add more search steps. For example, by using IPC classification codes. Yeah, this will be already a bit broader. Yeah, and may cover documents which escaped our attention using the CPC classification codes only. And if you just compare the effort you need to take in order to get the documents, and we plot it on the horizontal axis, the effort that is invested, on the vertical axis, the coverage, with the theoretical coverage of 100%, which is usually reached after an infinite amount of time, so not very realistic, then you can assume that it's in many cases some kind of Pareto principle which is followed. By using the core, already using the CPC classification codes, you can get already maybe 70% of all the relevant documents in your technical field. And with each additional field search, such as the IPC-based search, you increase the coverage further, but it takes a lot of time to do that. And it depends now on the situation, how far you would like to go. If it's just quick and dirty, I mentioned already, maybe a first step is sufficient. If it's about the freedom to operate, to build a factory or to enter the market that will cost millions of euros eventually, then you will invest a lot of time to aim at comprehensiveness and completeness. So really the searches will depend on the purpose you would like to achieve. And I prepared now two examples for you to practice a bit with me, to see how, at least in an exercise environment, this can work. There are two exercises. I would like to use you to use Espacenet again. In principle, Espacenet may still be open on your desk. And I would like to start to use publication numbers to retrieve pattern information and to understand the context. So the first exercise I would like to do with you, not to replicate what I presented regarding Hugh Hare as a use case, but at least to do some kind of finger exercises to check the bibliographic information for the pattern document, which has the publication number EP 2608-267A1. Yeah, so I would like to ask you to retrieve this document using Espacenet and answer two questions. The first one, who are the applicants and the inventors? And are there pattern documents which cite this very document? Should you have problems, please don't hesitate to set a note in the chat function or to raise your voice. Okay, I will present a sample approach in a few seconds time, but I would like to ask a question first. We have prepared some kind of quiz for you. Barbara, can you activate the quiz? Yeah, so the question is, we would like to ask is, what is the number of documents which were cited during the application and granting procedure of the patent application in question? So when you have managed to retrieve the bibliographic information, you should be able to see citing and cited documents. The question is, what is the number of documents which were cited? Are there any? No, no at all, none at all, 2 or 4. And we would like to ask you to send us a quick feedback before I show a sample approach to retrieve this information. Okay, many thanks for your feedback. Barbara, can you show the results? Okay, perfect. Most of you have found the proper answer. There's a good reason to answer too. As far as patent documents is concerned, I will just share my Obviousness screen with you to show how this may be done. This is the Obviousness screen again. You may type in, for example, the publication number as publication number. That may involve the risk that you also find documents where this number is not used as the publication number, but mentioned in the description, for example, or it is mentioned as a cited document or citing documents. If you use the field, so the patent number, you will be much more specific. This is what you may have found. Some have already indicated the applicant, which can be either a natural person or a legal person. In this case, it's a legal person. Here we see the complete description of the applicant. We see a number of applicants, inventors. What is safe to say is that inventors can only be natural persons. Yeah, so then we see the classification, priority, all the information we discussed already. If you are interested in the citations, you go to citations, and then you go to cited documents. Formally speaking, there are 4, so the correct answer is 4. The interesting thing here is that you can see cited patent documents, and you can see non-patent literature, which is indicated by the XP here. So it's more than just applications. We have 2 applications, and we have 2 non-patent documents. Together, it's the 4 documents I refer to. If you're interested in details for this, you can activate this link. You can see, for example, this document. Of course, you can go back, and the same applies in principle to non-patent documents where you don't see the document as such for copyright reasons, but at least you usually get some kind of general information as a reference. That can also be, in my view, very helpful. Excellent. So basically, we could identify the bibliographic content regarding this EP document. We could see the citations, and we realized that there are 4 citations, of which there are 2 non-patent documents cited during the application and granting procedure. And the fraction of non-patent literature cited can indicate the stage of this application regarding the research and the application phase. And that's often used as an indicator to see how close will a technology be to a market, at least as an indicator. That can be very helpful information for those who want to understand the situation. There's a second example I would like to show. It's an example related to additive manufacturing, most likely to 3D printing. Let's have a look at typical questions such as, we are expected to identify patent documents in the field of additive manufacturing with Ivukla Vivadent as applicant. It's an important applicant in the field of medical technology, especially in the field of dentistry. And when we now have to develop a search strategy, we have to identify the search concepts which are in this task. The first one is clearly that something has to be related to additive manufacturing. That means that we have to develop a search concept for this very concept, so search concept for additive manufacturing. Then clearly, second, Ivukla Vivadent plays a role, and it's indicated that it plays a role as an applicant. That's, of course, the second search concept, and they're linked with each other by saying with in natural language, which can be translated into and from a logical point of view. So what we would need to do is to create a search statement with the first search concept for additive manufacturing, then the Boolean operator and then as a second search concept, the applicant is Ivukla Vivadent. And it would just, in view of the limited time that is left, show the individual steps. But the principle applies to any technical field and usually any technical question. It may be only 2 search concepts, it may be 1, it may be 5, but the procedure is always the same. And it's based on logic assumptions. Okay, when we want to develop a search concept for additive manufacturing, we should remember that there are classification schemes in place. And it's always a good idea to have a look at them and identify proper classification areas which can be helpful. You can do that, for example, by using the CPC classification search browser, as I have shown already. Type in unique key concepts that are specific to that area, for example, additive and manufacturing. I use a certain kind of stemming here. Then we retrieve the result list, and for this, a ranking of patent classification codes used are displayed. And by browsing them, you will realize that an important area for additive manufacturing is the B33 area. That gives us already an indication of what we can do. Here, I just show you the hierarchical structure of that area. So there's in the section B of the CPC classification scheme for performing operations and transporting, a sub-area dedicated to additive manufacturing technology with certain sub-areas that I would like to be broad in this context and use B33 as the so-called subclass and dependent, so more detailed sub-areas. That can be translated into a search statement in ESPASnet. I use the classification field, which combines IPC and CPC codes. And I say, I'm interested in documents which have received the B33 for additive manufacturing or a subsection of that area, either as an IPC or as an CPC code. The second search concept is more straightforward. We know that Ivukla Vivadent shall be the applicant. I use the field for the applicant to be specific and create a string search statement for the second search concept. And then I combine both using the logic operator AND to create the intersection. And that's basically what I will then use in order to retrieve the documents in ESPASnet. This principle can be applied to nearly any technical field and to nearly any technical question. I type it in based on the development of the search strategy as shown. I just click on search and then I get a list of documents. When I created this list, it was 51 results, so essentially 51 patent families. I think today it's 52, so you can see that it changes over time, it usually grows, and it's dynamic. So it's always good to carry out these searches on a regular basis to stay on top of things and to keep pace with the developing content of the technical field in question. Yeah, that's a second example, which I use to illustrate a bit how you can develop your own search strategies. In practice, we will aim at providing more information regarding quantum technologies in the second stage of our training series. I mentioned already we plan it for April, where we address more subject matter and topics which are of interest to quantum technologies. Yeah, if you're interested in more information about patent searching for the time being, there is a lot of information available regarding Obviousness. There's online training available, which you may use. There are help files, which we can recommend to get more familiar with some terminology and some aspects. If you don't find the information either in these sources or the sources I mentioned already, or on the forum, there's always the help desk available, which you can address to ask specific questions for which you haven't found the answer elsewhere. And it would be great if you would also be interested in developing more skills in the field of patent retrieval. Of course, you can use this knowledge also for non-patent literature. It's the same principle. We offer e-learning, mostly self-paced courses on a specific web address. Please feel free to visit us at that web page in order to see what is available for you and to meet your needs. And we also developed a general web page with information about patent searching and patent retrieval in general at www.epo.org/searching. You're most welcome to use the information. It's made for you. Yeah, just to sum up information regarding patent information in general. Patent information is a very rich source of technical, legal, and business information. You may remember the estimate that 80% of all technical information is in patent documents only. Patent information should be used in all stages of the product development process, so not just when you prepare a patent application. It should already be used in the research phase during the product and development process, and it can be very helpful to address questions such as where's my market, who's on my market, which prototype is promising, who else is working in my technical field. Yeah, patent classification codes are very important. Try to identify them and make your search more efficient and effective. And it's in most cases a good idea to combine different search concepts because they make the search more efficient and comprehensive. And I recommend to use partial searches if you need a comprehensive search and a high recall. Yeah, that brings me to the end of the presentation. Thank you very much for your interest. I hope it was not just interesting, but also encouraging. Please use Obviousness or other search interfaces to retrieve patent information. After some time, you will get so familiar with the way of doing it and with the interfaces that it will feel like using Google or Bing. Okay, that brings me to the end of my presentation. I hand over back to Markus. Thank you very much.
Yeah, thank you very much, Christian, and also to your colleagues. I think this was quite insightful. So at least I have learned a lot, and I guess this is true for all of the other attendees. A question I would still have is, so when there would be a specific question of from attendees or so, whom could they contact? Would that be IP help desk, or is there somebody at the EPO?
That's a very good question, Markus, because now we represent different organizations in Europe that support quantum technology. It will depend on your willingness maybe to act as a relay, but I can't propose this, Markus. Would it be an option to use one of your addresses?
Of course.
Which they can send it, and then you send it to us, and we will find out who shall respond.
Yes, of course. I mean, we anyway keep in touch, and we're preparing the upcoming trainings, and maybe we can make this one of our, let's say, topics. So that's then an offer to all of the participants. So if there are any follow-up questions, something which will come up only when you have a second thought about certain things, then please don't hesitate to contact us on this, and we will relay to the responsible person in EPO or IP help desk. Okay, again, thank you very much for all the information, and also thank to the participants for staying with us for the whole time. I think the feedback in the chat is also quite positive, so everybody is happy, it seems. Then,
Marcus, may I ask a question? I see that there are a few questions left which need to be answered. We can do it either bilaterally or do it right now, whatever you prefer. I don't
know.
No,
I haven't seen that. So then let's do it. I think, what was the last question we responded to in the chat? I see there's...
I think we answered all of the questions until unitary pattern. So Carol's question regarding algorithm and other applications. Then there's a comment by Jörg. I think that's a comment.
That's a comment, yeah.
And there's a question regarding patent families.
Yeah, from Zed.
If you allow, I can quickly reply. There are different definitions for patent families. For example, the EPO uses a strict definition. It's the so-called DocDB simple family definition. You can see it in ESPOSnet. It really covers documents for the very same invention or the same invention. Then there's the so-called IMPADOC patent family definition, which relates to similar technologies. There are patent family definitions by commercial service providers. So my answer would be, yes, there's a variety of different family definitions depending on the source you use. And it's good to know them, and they are explained. They're explained, so you can see how they are defined.
Yeah, and I think a second question from Janine, I think this was actually responded already, but are there time limits for filing an opposition against a granted patent?
Yeah, Ricardo, if you would like to take over. If not, I can maybe answer the question on behalf of the EPO. There's a 9-month limit after the grant of the patent, at least for the EP system.
Indeed, sorry, I was muted and I didn't unmute myself. Sorry for that. But that's it, 9 months is the time limit.
I think that applies to most legislations, at least in Europe.
Yeah, okay. And next one, quite interesting. Can patent applicants propose their patents to be included under a certain classification or to be kept out of one?
Ricardo, would you like to take over? Shall I?
As you wish, Christian. We can you can do it, and then I can complement if there is anything.
My diplomatic answer would be is that the applicant may try, but the offices may not listen to them. So it's not that this will be taken into account by default. Maybe it can be an inspiration, but it's really the work of the experts who take the decision for or against a certain patent classification code.
That's correct, Christian, indeed. So the classification is done by experts, and it's completely independent of the applicants. Many applicants, what they do is they cite prior art in their own patent applications, and this prior art may give also a hint, but generally it is the experts in classification who do this in an independent way. So, yeah.
Okay, and well, the last one, I think it's not meant as a question, and I don't know exactly. So it's P-type graphene-based transistor, and it's called AHP GmbH. Sorry for
that's the sample solution to the first exercise.
Exactly. So, and I think with this we're through. Are there any additional comments or questions? So if there are, then it's now the last chance to speak up. But I think this is not the case. So again, we received some thank you. So it was very valuable. Thank you again to all the presenters for helping us so that we find our way of how to better patent quantum inventions. And I wish you well, stay healthy, and we see each other at our next online training. We will certainly invite everybody who participated this training, but of course we will also announce that more broadly. So I don't know, Christian or Giovanna, any final words from your side?
Joanna, will you take over?
So, hello, everybody. So I'm very pleased that so many questions were asked. So it looks like that there is a clear need for follow-up training that we are very, very happy to offer very soon in cooperation also with the European IP Help Desk. So let's stay in touch and tuned. So you will on a regular basis through the quantum technology team, through our colleagues there, you will be receiving also continuously our offer, but we will also offer you a specific customized training in the future. At the EPO, we have many initiatives that may be also of relevance to you. So we are happy to share the information very soon for 2022. Thanks.
Okay, good. Then I wish you a nice weekend and stay well in these times.
Thank you very much. Thank you, everybody. Have a nice weekend.
Bye-bye.
Thank you, everybody. Nice weekend to everyone.
Thank you. Goodbye.